State of Kansas versus Tremaine J. Robinson. Jared Regier, Assistant County Attorney appearing for the state. Mr. Robinson, are you here?
I am here representing the name, ma'am.
Today's courtroom disaster comes with a public service announcement. If you're out there huffing glue and convincing yourself the law no longer applies to you, maybe it's time to stop before you end up exactly like the sovereign citizen in this video. We're heading straight into Kansas and into the courtroom of Judge Webster, a no-nonsense judge who clearly has zero patience for legal fantasy roleplay, while the prosecutor walks in sounding less like a normal attorney and more like Skynet's T-1000 in a suit, cold, relentless, and absolutely ready to terminate every ridiculous argument thrown his way. The defendant truly believes he's discovered some secret loophole that makes him untouchable, but what follows is a complete courtroom meltdown packed with delusion, interruptions, failed sovereign citizen logic, and brutal reality checks that only get more painful as the hearing goes on.
All right, you need to start your video, please. And you are, is it Tremaine or Tremaine?
The name I'm representing is Tremaine.
Tremaine. And how do you pronounce your middle name?
J.
Tremaine J. Robinson.
On and for the record, ma'am, I want to say that I want to give notice to reserve all my rights and inform the court that I'm not here to testify or plead. I'm here to make a special appearance to challenge the jurisdiction only.
Things went off the rails almost instantly when the defendant tried pulling the classic sovereign citizen move of demanding a special appearance, except there was one tiny problem destroying his entire argument from the start: he wasn't even a licensed attorney. The judge wasted absolutely no time pointing out the obvious, making it painfully clear that you can't legally make a special appearance on someone's behalf when you have zero authority to practice law in the first place.
All right, anything else?
Yes, I would like to see evidence of a charging instrument.
Were you not given a copy of the ticket issued by Trooper Collins?
The charging instrument that I am referring to is a sworn affidavit of the client, of the person that I've hurt.
This is a speeding ticket alleging that you did on March 27, 2023 at 8:48 a.m. operate a motor vehicle in Butler County, Kansas at the speed of 92 miles per hour when the posted maximum speed limit was 75 miles per hour. So this would have been out on the Kansas Turnpike, Highway I-35. Now, what else were you wanting to know, sir, as the allegations against you?
I would like to see evidence of the affidavit of the people that I've hurt. This is a victimless crime if there's no one that I've hurt.
The judge then delivered a brutal reality check that completely shattered the defendant's logic, pointing out that the only reason he thinks his reckless behavior is acceptable is because nobody got hurt this time. Speed limits aren't optional suggestions that disappear just because someone personally disagrees with them. They exist to stop chaos before tragedy happens. The courtroom grew quiet as the judge explained how dangerous that mindset really is, because if everyone decided their own right to travel overruled the law, then somebody else could easily choose a speed far beyond what this defendant considers safe, and suddenly it could be his own family paying the price. In just a few sentences, the judge exposed the massive flaw in sovereign citizen thinking. The law doesn't wait for disaster before stepping in, it exists to prevent disaster from happening in the first place.
Well, the victim would be the state of Kansas in that you violated the laws enacted to protect the people of the state of Kansas, but this is not the type of crime which would require or have individual names listed. So, your next point, if any?
My next point is, as I stated, ma'am, I'm not here to testify, I'm not here to plead. I would like to see the affidavit with 2 signatures for the person that I've hurt. If I didn't hurt anybody, there's no crime.
All right, well, I'm going to proceed. So again, Mr. Regier, are you ready to proceed?
I am, Your Honor. As a preliminary matter, It would appear that while Mr. Pate was still involved with this case, but before the motion in order to withdraw was filed by counsel in August, the defendant did file a piece of correspondence of some kind. It does appear to include a motion for discovery. However, that particular document would appear to be procedurally deficient. It does not appear to include a certificate of service. The only address listed appear to be on page 1 involving the defendant, the traffic court clerk at an address both in El Dorado and in Topeka, as well as the office of the Attorney General. Certainly no service on my office, so there is that.
In other words, the defendant's entire motion was already dead on arrival because he failed to properly serve the other side, meaning they were under absolutely no obligation to take any of his arguments seriously in the first place. The judge basically spelled out that maybe firing his lawyer wasn't the genius move he thought it was, because an actual attorney probably could have prevented this legal train wreck before it even started. But then the hearing took an even funnier turn when the prosecutor admitted he did receive a mysterious 7-page packet from the defendant, and somehow that document managed to cram in practically every sovereign citizen argument ever invented. From jurisdiction nonsense to right to travel claims and pseudo-legal word salad, the packet read less like a legitimate filing and more like a greatest hits collection of internet courtroom fantasy theories, proving this guy wasn't just committed to the act, he was fully all in.
The subpoena was issued July 7, 2023 for Trooper Collins. Then on July 31st came a correspondence from the defendant as referred to by Mr. Regier herein. Looks like it's about 7 typed pages, and as counsel said, it's entitled Challenge for Jurisdiction and addressed to Butler County District Court Clerk, Butler County District Court Clerk, Office of the Attorney General Derek Schmidt. And it mentions subtitles under the following case law. I request case 2023 TR 1193 be dismissed. Talking about municipal court, administrative law in the next paragraph. Ministerial offices being incompetent to receive grants of judicial power from legislature, citing a case, looks like 140 California 1, and stating that once jurisdiction is challenged, the court cannot proceed. Next paragraph, the law requires proof of jurisdiction to appear, talking again about an administrative agency, and tribunals, judicial tribunals. Alleged personal jurisdiction of the defendant is void. Court has no jurisdiction, no discretion to ignore what is alleged to be lack of jurisdiction. And then it is signed by a signature that I'm not sure I can make it out, but it says Robinson-Tremaine, J, beneficiary.
At this point, it honestly feels like judges everywhere are finally catching on to the sovereign citizen -: name spells routine, or maybe these defendants have become so committed to the nonsense that they're now carefully typing out every bizarre formatting trick they found on some late-night internet forum. Either way, the courtroom reactions are becoming more priceless by the day, because what these people believe is some secret legal code capable of defeating the justice system usually ends up sounding like complete gibberish the moment it's read out loud in front of an actual judge.
The next page talks about a legislative act of constitutionality, substantial harm, right to a trial by jury, all power inherent in the people, legislative assembly. Officer Collins K. issued the ticket summons on the side of the road and did so without an affidavit of complaint approved by the clerk of the court or judge. Quote, I request a certified copy of that complaint from my accuser stating who it injured. Continuing, quote, no bill of attainder or ex post facto law or law impairing the obligation of contract shall ever be passed. End quote. Then he goes on to request this Officer Collins, quote, speed detection device, including model and serial number and year installed, Any documents pertaining to the training certification, disciplinary reports of the trooper, tuning port calibration records, certification records for the device, more information about calibration records, device records. It says the information requested directly relates to reliability and accuracy of evidence against him. So he's wanting proof provided within 21 days, or an immediate dismissal based on Rule 12, which comes from the Federal Rules of Civil Procedure. Under 28 U.S.C. 1746, Section 1. And then it is signed declaring or certifying or verifying or stating under penalty of perjury under the laws of the United States of America, executed July 26, 2023. Again, signature, and then in brackets, Robinson, Tremaine, J, without prejudice. Pretty much the same things he's gone over before. Talking about the judicial officer has to cease because of the administrative law, and pretty much standard language that is used by folks who call themselves or are considered sovereign citizens.
The judge absolutely nailed the situation from the very beginning, reacting like she could practically sense the sovereign citizen nonsense coming through the Zoom screen before the guy even finished speaking. You could tell instantly that she wasn't even slightly impressed by the recycled legal fantasy routine, because unlike the defendant, she's heard every version of these arguments 100 times before. The moment he started drifting into the usual pseudo-law script, her expression basically said, "Here we go again," as she calmly shut down the performance without giving him the dramatic reaction he was clearly hoping for. What the defendant thought was some groundbreaking courtroom strategy just came across as another tired remix of the same failed sovereign citizen talking points judges deal with on a regular basis.
Revocation of signatures on the final page 7, mentioning that, quote, "It is on this date, July 27, 2023, I, Tremaine J. Robinson," it's Tremaine-J, Robinson, in the county of the Seminole of the state of Florida and a zip code, a natural man, attorney in fact, as a living human being who's the beneficiary of Tremaine J. Robinson trademark. Swear that the information in my sworn statement is truthful to the best of my knowledge and understanding. I, Tremaine J. Robinson, beneficiary of Tremaine J. Robinson, revoke my signature on any and all pages of any and all tickets, summonses, contracts, and/or agreements signed by the side of the road in the state of Kansas by Officer Collins K., March 27, 23, and then signature authorized representative and attorney in fact. So after that document was filed pro se, apparently, by the defendant, Mr. Pate filed a motion to withdraw due to the defendant wanting to proceed pro se, and that was authorized based on the previously referred to 7-page document. It would indicate at the time to the court that Mr. Robinson did want to proceed pro se, so Mr. Pate, attorney, was allowed to withdraw. And so here we are. Now, Mr. Robinson, normally I would be upset that you filed what appears to be in part a motion for discovery and you didn't get that. However, you did not address that document to anybody but Butler County District Court Clerk Traffic Court, Butler County District Court Traffic Court. You sent one to a P.O. box in Topeka, and then you sent a copy of it to the Attorney General. But you did not send it to the Butler County Attorney. Therefore, he did not know you were trying to get discovery.
Ma'am, I do have a tracking number that says it was delivered at the Butler Attorney.
Okay, well, that's not on file. What do you want to present that at this time?
Yeah, someone signed for it yesterday.
The courtroom nearly descended into pure disbelief when the defendant casually admitted that he had only served his discovery motion the day before, apparently expecting the prosecution to magically gather officer records, equipment information, and every other document he demanded overnight. The judge's reaction basically screamed, "What fantasy world are you living in?" as she reminded him that this is real life, not some cartoon version of the legal system where government agencies instantly drop everything to satisfy last-minute requests. In reality, discovery can take weeks, sometimes longer, which is exactly why procedural rules and filing deadlines exist in the first place. But like so many sovereign citizens before him, the defendant seemed convinced those rules somehow applied to everyone except him. Unfortunately for him, the deadline had already passed, and the court had absolutely no interest in bending reality to accommodate his terrible planning.
And this document that I'm giving the benefit of, it's a multi-subject document, but this document filed by the defendant that I'm giving the benefit of including what he offers as a motion for discovery was not filed with the clerk until July 31st. So that was after the statutorily required 21 days. And then it was not filed upon the prosecutor who would have, or the witness who would have held any evidence, but rather again on Butler County Clerk in Topeka, Kansas, that to my knowledge doesn't exist, the Butler County Clerk in El Dorado, and Attorney General then Derek Schmidt in Topeka. And that's if it was served, if I take the defendant's benefit of the doubt, that was saying it was served sometime yesterday before today's 1:30 trial, the court has to decide if that later time was reasonable, and I do not find that it was reasonably served on the county attorney. I am at this point going to say that any last-minute motion for discovery is denied, and we are prepared to go to trial. Now, I've lost you, Mr. Robinson. Are you still somewhere available?
No.
What are you doing there with your computer?
Right now, I was looking for a document, but no, I am not available for trial.
At that moment, it became painfully obvious that the defendant was completely unprepared for what was coming next, because while he was still scrambling to piece together his sovereign citizen talking points, the prosecutor was already several steps ahead and ready to crush every single one of them before they even left his mouth. Armed with actual case law, Kansas Supreme Court rulings, and years of legal precedent, the prosecutor systematically dismantled the usual right to travel, no jurisdiction, and pseudo-constitutional arguments that sovereign citizens love to recycle online. It felt less like a debate and more like watching someone bring a stack of internet conspiracy printouts into a fight against a legal machine built entirely on facts, procedure, and court decisions, and the outcome was just as brutal as you'd expect.
We're going to proceed with trial. So please put yourself back in front of the camera. Follow the court's order, or you could be found in contempt. I don't want to do that. Thank you, sir. All right, Mr. Regier, did you tell me you did or did not have any opening argument or opening statements?
Your Honor, I did not specify one way or the other, but the state would waive any statements at this time. However, if the state would respectfully request leave the court to read from some Kansas case law put down by the Kansas Court of Appeals, which does appear relevant in this matter.
All right, you can document those for the record.
Yes, Your Honor. The state would now respectfully read from State v. Mayor. It's a Kansas it was a Kansas Court of Appeals case, 466 P3D 1236.
Go ahead.
Your Honor, in that particular case, involved a sovereign citizen, where the court noted in the memorandum opinion.
Objection, hearsay. Objection, hearsay.
Case law is not considered hearsay or.
I'm not a sovereign citizen.
At some point, the excuses and mental gymnastics became so ridiculous that the only thing left to do was call it exactly what it was. The defendant kept desperately trying to convince himself that he wasn't a sovereign citizen, repeating the same recycled arguments while pretending they somehow meant something different this time, but nobody in the courtroom was buying it. Reality had already caught up with him, and while he clung to his imaginary legal loopholes like a man stranded on the world's smallest branch, everyone else could clearly see the truth. This was textbook sovereign citizen behavior from start to finish. No matter how many times he tried to rename it, redefine it, or dance around the label, the courtroom had heard it all before, and they were calling it exactly as they saw it.
All right, he's not a sovereign citizen. Go ahead, Mr. Regier.
Yes, Your Honor. In that case, the Kansas Court of Appeals noted, quote, the defendant thinks the law does not apply to him. He avows that he, unlike other citizens, is sovereign and immune from prosecution. The court went on to address the issue of venue, which the court noted that, quote, venue is generally proper in the county where the crime was committed. I will address that momentarily, as well as referring to KSA 22-2602. Additionally, and perhaps most relevant to this court, the defendant in that case, quote, complains that his objections to the trial court's jurisdiction to prosecute him arise from the claim that he is a sovereign citizen. This is not the first appellate court to deal with such a claim. Another panel of this court used analysis of federal case law to reject a similar claim. And then quoting from Seventh Circuit and Eighth Circuit cases, quote, an individual's belief that his status as a sovereign citizen puts him beyond the jurisdiction of the courts has no conceivable validity in American law. Regardless of an individual's claimed status of descent, be it as a sovereign citizen, a secured party creditor, or a flesh and blood human being, that person is not beyond the jurisdiction of the courts. These theories should be rejected summarily, however they are presented. In referring to an Eighth Circuit Court of Appeals case, United States v. Yagam from 1992, Yagam found similar issues were completely without merit and patently frivolous. They rejected those issues without expending any more of these courts' resources on their discussion. And again, the Supreme Court also referred to a Kansas Supreme Court case from 2019. Quote, our Kansas Supreme Court has recently affirmed the Requena panel. The court held that the claims of sovereign citizenship are ultimately meritless. Thus, if the defendant's arguments are on appeal, rely on his sovereignty claims, we hold they are meritless. And with that, I would respectfully call my first witness to the stand.
All right. I do find that this court has jurisdiction and venue to proceed, and the arguments made by the defendant in the 7-page document referred to previously are summarily dismissed.
With absolutely no surprise to anyone watching, the judge wastes no time shutting it down. The defendant's motion to dismiss is denied outright as frivolous, clearing away yet another attempted sovereign citizen roadblock. Rather than dragging the hearing through every minute of routine testimony, the court quickly fast-forwards through the officer's statement, which is largely straightforward and unchallenged, focusing only on the key parts that actually matter. From there, the proceedings shift directly to the moment the defendant has been waiting for, his chance to cross-examine the officer about the traffic stop, setting the stage for what's about to become the next round of courtroom tension.
And did you ultimately write the defendant a citation for speeding?
Yes, I did.
Or an annual redirect? No further questions.
All right, Mr. Robinson, this is your opportunity to cross-examine the trooper. You can question him about his testimony. It's not quite time for you to give your own testimony, so these addresses to the trooper have to be in the form of question. You don't have to question him, but you can. Would you like to?
No.
All right. Mr. Regier, any further evidence?
None from the state, Your Honor.
Okay. The state rests then, Mr. Regier?
The state does so rest, Your Honor.
Mr. Robinson, the state rests. They have presented all the evidence they intend to. Would you like to present any evidence? Again, you don't have to. Your silence will not be used as a sign of guilt. But if you'd like the court to consider your position, I'd be happy to do so.
I don't understand.
Well, do you want to tell the court your version of what happened?
No.
All right. You don't wish to present any evidence then. Am I understanding you correctly?
The evidence that I tried to present, you won't give due process.
The judge made it clear there was no room left for procedural games or last-minute legal improvisation. pointing out that the defendant hadn't actually presented any real evidence, only a motion to dismiss that had already been denied. With the formalities out of the way, the court shifted focus and gave him one final opportunity. If he had any actual evidence or testimony to support his position, this was the moment to present it. In other words, the courtroom wasn't interested in arguments anymore. It was time to see whether the defendant had anything substantial at all, or whether the entire case was going to collapse under the weight of its own claims.
Okay, but do you want to give any testimony about the events leading up to this ticket, March 27, 2023?
No.
All right. Well, I will find the defendant guilty of speeding 92 and a 75. The scheduled fine is $87. Court costs are $108. The total due will be $195. Sir, you do have the right to appeal this proceeding. You can appeal it to the Kansas Court of Appeals. You have up to 14 days to file that notice of appeal. Your appeal bond will be in cash, the same as what your court costs and fines are. That's $195. Can you have this paid, this fine and cost paid in 14 days, or do you need some time?
I'll follow appeal.
The judge closed things out with a blunt reality check, making it clear the defendant didn't really have a solid foundation for any appeal in the first place. At best, he might try to challenge the denial of his motion to dismiss, but since he offered no actual testimony or meaningful evidence during the hearing, there's very little for an appellate court to even review, because appeals courts don't exist to give anyone a second chance to retry their case from scratch. In other words, there simply weren't any real grounds to overturn the conviction based on how the case was handled. And with that, the video wraps up here, but the story doesn't end just yet. In the next one, we move on to a sovereign citizen who actually managed to take his arguments all the way to the Court of Appeals, getting his brief moment in the spotlight before reality catches up with him there too.